Good afternoon, everyone, and good morning to those of you who are on specific time, and welcome to the webinar, Opioids and Drug Delivery Resulting in Death. Today's program is hosted by Equitas and presented by Tonya Lupinacci, the Assistant Chief of Trials at the District Attorney's Office of Montgomery County, Pennsylvania. My name is Jonathan Curlin, and I'm an attorney advisor at Equitas, and I'll be moderating today's webinar. If you have a question during the presentation, please enter it in the chat box to your right. Time available, we'll answer those questions at the end of the webinar. You are also welcome to contact us directly at any time following today's presentation, and we'll send you contact information during our follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. In addition to our website, you can also follow Equitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Today's webinar is supported by the U.S. Department of Justice, Bureau of Justice Assistance. The information presented in this webinar does not necessarily reflect the views of BGA. Now, I want to give a little introduction to our presenter that we're very lucky to have today, and I'm very privileged to know her, and actually she lives and works in the same jurisdiction I do, although a county over. So folks, everyone, Tonya Lupinacci, she currently serves as the Assistant Chief of Trials of the Firearms and Narcotics Division in the Montgomery County District Attorney's Office. Mrs. Lupinacci handles all aspects of the District Attorney's initiatives to combat the current opioid epidemic that plagues our communities with record high overdose deaths. She handles the prosecution of homicide cases involving the crime of drug delivery resulting in death, as well as the prosecution of drug offenders from street-level dealers to leaders of drug trafficking organizations. Mrs. Lupinacci also spearheaded the grand jury investigation into opioid epidemic in Montgomery County, which resulted in a comprehensive report and recommendations that was released in May 2017. Mrs. Lupinacci has been a member of the District Attorney's Office since 2003. She served as captain of the narcotics unit from 2008 to 2012. In 2012, she left her full-time position to work part-time for the DA's office in order to spend more time with her 3 young boys. In 2017, she rejoined the office in a full-time capacity, and as the former captain of the narcotics unit, she continues to handle all aspects of drug prosecution, from pre-arrest investigations and proffers to the trial of drug offenders. Her experience also includes the prosecution of numerous wiretap cases involving large-scale narcotic rings. She has prosecuted multiple wiretap jury trials resulting in guilty verdicts. Mrs. Lupinacci litigates written and oral motions, including consolidation, bail and suppression motions, as well as post-conviction motions. Mrs. Lupinacci has attended both Top Gun courses for investigators and prosecutors. She has taught courses for the Pennsylvania District Attorney's Institute, Pennsylvania State Police, and the Montgomery County Drug Task Force. She is also a member of the Criminal Justice Adjunct Faculty at Montgomery County Community College. Mrs. Lupinacci is an active member of the Montgomery Bar Association, where she is a member of the Women in Law Committee, as well as the 2019 Leadership Academy. During her time as a member of the Leadership Academy, she helped spearhead the first ever Montgomery Bar Association Reentry Day for recently released incarcerated persons. The Reentry Day provided assistance to those persons seeking secure, safe housing, access to transportation, obtaining gainful employment, and accessing drug and alcohol treatment. Ladies and gentlemen, you were very fortunate to have Tonya present today's content. And I'm going to turn it over to her because I'm more excited to hear her than listen to me. So I'm going to turn my screen off and give it to her. Thank you so much for joining us, and thank you, Tonya, in advance.
Thank you, John. Thank you, everyone. I'm going to switch over and share my screen. Switch over to the PowerPoint here. Thank you so much for having me. It really is an honor to be here and provide the information and training and experience and knowledge that I have in my job. And I really look forward to hearing from all of you. So thank you for having me here to discuss such an important topic that has impacted all our communities. And I will venture to say every community in the United States. The opioid crisis is pervasive, extensive, and far-reaching. It has deadly consequences and has destroyed thousands of families in its path. There is no community immune from it. It knows no race, it knows no religion, it knows no economic status. We have seen it and experienced it in every corner in my jurisdiction, which is Montgomery County, Pennsylvania. Montgomery County sits outside of the city of Philadelphia. We have approximately 850,000 people who live here. Our district attorney's office consists of approximately 150 employees and 50 prosecutors. And so together, we have come together and have put our best foot forward in fighting this crisis. And I'm really proud and excited about sharing what we've done in Montgomery County and also learning from all of you. So as much as this crisis has affected our county here in Montgomery County, we have also looked at our neighboring counties and across the state and across the United States to help us understand the epidemic and to move forward. And I'm hoping to share with you today what we're doing in our office as prosecutors and law enforcement officers. So where do we start? We start with the addiction itself. Understanding the disease of substance use disorder is critical to knowing how to respond, to coming up with a plan to respond. And this photo that I'm starting out with was taken by one of our opioid task force investigators at a crime scene, at an overdose death crime scene. It is from the bedroom of a 24-year-old female. And I think it really depicts the ravages and strength of this addiction. This woman lived with her father. Her father never went upstairs into her room. And when the police responded to her death, they found this. And if you take a closer look at this photograph, all those blue and pink pieces of paper are used bags of heroin. So during the course of my time in working with these investigations and cases, I have spoken to many people who suffer from the disease. I have spoken to their family members. I have spoken to family members who lost sons and daughters to overdoses. And there is one person for me who really stands out in describing what this addiction is like. In addition to this photograph, part of my job, as John had mentioned, was to lead the grand jury investigation. We'll talk about that later. But one of the women that I met during the course of that was a grandmother whose grandson was living with her, and he had suffered for the addiction since he was 16 years old. She personally, despite her own medical condition and she had issues with immobility, had to use the life-saving drug Narcan on 3 occasions that brought him back to life. Unfortunately, on the 4th occasion, he died. And she shared with me a conversation she had with her grandson shortly before he died. And she was pleading with him. She was pleading with him to help her understand why he continues to use heroin and causing such self-destruction. And what he said to her was really eye-opening for me. He described it as having heavy chains continuously wrapped around his body, and he's just sinking in water, sinking down and drowning. And I will never forget that conversation with her, because if we could have a glimpse into the addiction, that for me had a lot of impact. So the addiction is very strong. And for those who don't understand it and don't understand why people continue to use despite all the ramifications, it is because they cannot stop, and it is a disease. So the CDC states, and we here in Montgomery County know, that data collection is critical to understanding the nature of the crisis in our community. It is critical because it provides crucial information to decision makers and stakeholders in the community so that they can identify and target and make critical decisions in response to combating the crisis. So data collection is very important. We here in Montgomery County are very lucky because we have a comprehensive approach to the collection and analyzing data that transcends multiple departments across our county and in our government. The Department of Public Safety, the DA's office, the health department, the coroner's office, the police departments, our county detectives that work for the district attorney's office, we share in this data collection. And if your jurisdiction isn't quite there with regards to collecting data, there is funding and resources out there on the state level as well as the federal level that could help support that. There are numerous grants at the state and federal level that are available that could get your jurisdiction up and running. And it really is important because it really gives you a snapshot and a scope of the crisis in any given year. We believe that looking at the past helps you understand the present and helps you come up with a plan for the future. In 2018, Montgomery County was awarded a $1 million grant from the Department of Justice to fund what is called the Emergency Medical Overdose Surveillance System. And I am by no means an expert in this, but what it is, it's a storage of public safety and public health information and qualitative data about drug use patterns of non-fatal and fatal overdose victims. And all the stakeholders share in that information so that they can target hotspots. So for example, us in the district attorney's office and in law enforcement can use that information by targeting hotspots to try to curtail drug trafficking and suppliers. And taking a look here, these statistics right now in front of your screen, in your screen here, is collected by our coroner's office in Montgomery County. And the data provides a snapshot and the scope of the crisis in any given year. So the slideshow shows the total drug-related deaths, and when we started collecting this information in 2002, all the way up through 2019. And if you go back to 2002, there was just 39 total drug-related deaths in that year. We have a spike in 2009 to 111, which correlates with the rise in the abuse of prescription opioids. And it continues to rise, and there's a huge jump in 2016 with 249 deaths, and a drop, which we will talk about in a minute, in 2017 to 2018. So in 2016 at 249 deaths, and there's a small drop in 2017 to 245 deaths, and then a more significant drop in 2018. So the drop from 2017 to 2018 is interesting because it is also a mirror to the national statistics that is maintained by the CDC. In that same year nationally, there was a 4% decrease from 2017 to 2018, but the number of drug overdose deaths was still 4 times higher in 2018 than it was in 1999 nationally, and for us in 2002. But unfortunately, we are right back up here in 2019 with 250 deaths, our highest yet. Never have we seen so many deaths at this rate. So what happened? I'm sure you have all may have seen this photo from the DEA. What this photo shows us is the power of the synthetic drug fentanyl. What you see on the left is about 30 milligrams of heroin, which is a deadly dose. And what you see on the right here is about 3 milligrams of fentanyl. It just takes just that little amount of fentanyl to kill somebody. Fentanyl is a synthetic opioid that is 40 to 50 times stronger than heroin or morphine. It is made in a lab, it is legal, and it is controlled, but it's being sold on the street as a heroin substitute. It provides a greater high for those that are addicted, and now we are finding that those who are addicted are seeking out fentanyl. There was a time there, at least from the cases that were crossing my desk, where we had unsuspecting, we still do, but there was a time where we had unsuspecting users who were seeking out heroin, but they were getting fentanyl, and some had resulted, unfortunately, in death, many in overdoses. So even worse, beyond fentanyl, we are now seeing even more synthetic opioids that are made illegally, such as analogs of fentanyl, such as carfentanil, which is a horse tranquilizer, or methyltriphenol, that are even stronger than just fentanyl. We also have a policy in place at the Montgomery County District Attorney's Office to protect our investigators and detectives. Traditionally, before this onslaught of heroin and fentanyl investigations into overdose deaths, the police would respond to a crime scene, they would collect the evidence, and they would perform what are called field tests right there on scene. In Montgomery County, we no longer do that. We have a protocol and policy that our law enforcement officers are to collect the evidence and send it straight to the lab in order to protect them. Taking a look at some of our numbers here with regards to the effect on fentanyl and the opioid epidemic, this depicts the comparison of drug overdose deaths to fentanyl-related deaths. So for example, in 2018, we had a total of 210 drug-related deaths. 152 of them were fentanyl related, roughly 72%. In 2019, we had a total of 250 drug-related total deaths, and 159 of them were fentanyl, was fentanyl related, roughly 63%. So our role as prosecutors has certainly changed in light of this crisis. Our district attorney, Kevin Steele in Montgomery County, is forward-looking and had a vision. He was elected in 2015 and took office in 2016. And he considers the opioid epidemic as the #1 public safety issue. And when he was elected, he decided with myself and some other members of our office that we were going to fight this epidemic on multiple fronts. We realize and we understand that we cannot arrest our way out of it, but it starts with an understanding. And to get that community understanding, what is going on, who is affected, what is not working, what is working, what do we need to do better, we convened an investigative grand jury. So in April of 2016, we convened the Montgomery County Investigative Grand Jury to hear testimony on this public safety issue. And it consisted of more than 30 witnesses over 13 months from all facets of the epidemic, family members of overdose death victims, those currently suffering from substance use disorder, law enforcement, the Pennsylvania Medical Society, treatment providers, government leaders, and they all told us about their understanding of the epidemic, its impact on them, how they were responding, what they are doing, if anything, to combat it, and what we can do to help in the future. And in the end, after 13 months, we issued a comprehensive report, which you can find on our website at the Montgomery County District Attorney's Office, titled The Opioid Epidemic. And it was a comprehensive report that really dug into what was happening in our community, which is necessary to understanding what we can do as law enforcement, or what other partners and stakeholders can do in your community to respond to it. And the grand jury came up with 6 overarching recommendations to tackle the epidemic, some of which include increased collaboration and better data collection with our regional partners, and law enforcement agencies. Some of the recommendations include the establishment of better treatment protocols, such as warm handoff initiatives, mobile response units. One of the recommendations also included a pre-arrest drug court for young offenders at the Magisterial District Court. We already have a drug court at the county level, but one of the recommendations was to go beyond that and have a similar type of program at the Magisterial District Court, which in Pennsylvania is a lower court before trial where probable cause is established when somebody is arrested. So we wanted to try to intervene and target young offenders who may be just starting down that road to drug addiction. So part of the grand jury report and the one theme that was overarching from the investigation, and that it really is necessary, is bringing together our county and state partners and our local police departments. That was really key. It's the collaboration and working together to implement life-saving measures and diminish the stigma that surrounds those who suffer from this substance use disorder. We needed law enforcement buy-in, and we got it. It is a big part because they are on the front lines. They're the ones who are having sometimes contact with individuals who are suffering from this disease. And as one law enforcement officer had shared with me and others, is that several times law enforcement are responding to overdose scenes on multiple times just in a 24-hour period for the same person. So part of that was our membership and our partnership with the Montgomery County Overdose Drug Task Force that was also formed in and around the same time as the grand jury report. And the express purpose was to work together within our own agencies and combat and curb the growing drug-related deaths. The initial focus was to establish short and long-term goals, which were met and continue to be implemented. It is our belief that in Montgomery County, the current statistics would be far worse had not been working together with the stakeholders and partners in our community to tackle it. So part of what we also do is working with the drug and alcohol departments and the health departments. Our police departments have participated in what is called the warm handoff program. This was also a recommendation from the grand jury investigation. So our drug and alcohol department and our health departments are fantastic. We have what we call the warm handoff, in that every police department in our county have their business cards that they can provide anyone, whether it's a family member just walking in from the street asking for assistance for a loved one, whether it's someone that they during their duties are coming in contact with, whether it's somebody that may be arrested for possession or retail theft or some other type of crime, that they have the information at their fingertips to provide for those who need treatment. Talking about that police buy-in, so it's been about 3 years now, but a goal of the grand jury report and a goal of the task force was to expand the police response to overdose emergencies and to get all police officers trained in the administration of Naloxone, which is the life-saving drug, which will quickly reverse the symptoms of an overdose. So for about 3 years now, all police departments in my county have been carrying the life-saving drug Naloxone. Officers are trained how to use it. When the officers use it, the information is reported to our Department of Public Safety, and data is collection on that use. And what that does, it allows the district attorney's office and law enforcement and treatment providers and other stakeholders in Montgomery County to identify hotspots where we're seeing a lot of overdoses and that we can respond accordingly. The district attorney's office has funded the police use supply of Naloxone, and we use that through drug forfeiture money. One of the other measures that we are doing in Montgomery County District Attorney's Office is enhancing our drug take-back efforts. That was also discussed in our grand jury investigation. It's very important, as many of you know, that addiction starts right in our medicine cabinets, oftentimes with the presence of used or expired medication that have been sitting there for years. Children have access to them. Those who are dependent have access to them. So what the district attorney's office has done is that we have 2 drug take back efforts every year, where we literally collect thousands of pounds of unused and expired medications. We also have prescription return boxes that are present in about 99% of our police departments throughout the county. So anyone at any time can go to their local police department and and dispose safely of expired and used medication. And the goal is to get that unwanted and expired medications out of medicine cabinets and out of the reach of those who are vulnerable. We've also enhanced our community outreach efforts. Our district attorney used drug forfeiture funds to buy this little mini mobile car that makes its way to several different resource fairs, senior living facilities, grocery stores, national nights out. Just one to promote community engagement with us in law enforcement, to provide warm hands-off information from anybody we may encounter at these types of events. And we're really just send it anywhere where people can gather. And we also collect the expired and unused medications that people may have. It's driven by our county detectives, and it accepts all types of medications, and it really does send the clear message to clean out your medicine cabinets. The best way to save lives that we have found from people we have talked to, parents who've lost loved ones, and educator, is to provide information and education to students. And it doesn't start in high school. We are out talking. We have prosecutors together with detectives who go out to elementary schools, middle schools, and high school. But we have found that in high school, it's almost too late. So we try to target the students who are younger. The best and most successful programs that we have experienced is when the parents are also present. And so we talk to the kids, yes, but we also talk to the parents, and we help them with drug identification, warning signs. And at the very least, it starts a conversation between a parent and a child. Sometimes a conversation that really doesn't take place until we have these types of programs, which sparks the interest. There are many parents out there that believe, oh, not my kid, not my school district, not my school, not my community. So part of our job is educating and informing parents that it is everywhere and providing them real, credible information to help them understand the epidemic and help them to understand what the warning signs are. And the message to the kids to take care of each other, look out for each other. It's okay to say something if something doesn't seem quite right among your friends. There are many moms who I've spoke to who lost sons and daughters that really wished one of their friends had said something. So that is a message we try to share with our student population. So in addition to all these other efforts, one of the recommendations from the grand jury report, and is an ongoing task of the Overdose Drug Task Force that we are partners on, is the continued support of diversion courts, such as drug court, veterans court, and behavioral health court. We have all 3 of those diversion courts here in Montgomery County, and all 3 deal with the opioid epidemic. Drug court is an alternative sentencing option for those who have drug possession cases or theft cases. Our drug court in Montgomery County has seen great success, and it's been around for a while. It did not start in response to the opioid epidemic. Our drug court started in 2006 and has been a huge success, but is definitely ramping up their efforts in recent years in response to the opioid epidemic. And what it is, it provides a long-term comprehensive program that combined with intensive treatment and court supervision. When somebody has to apply to drug court, and if they are admitted, they go through the program anywhere from 18 months to 24 months before they graduate. And it's not easy. Some people are unable to complete it and they will face their criminal charges. Others who are evaluated and go through, they're evaluated for what they need, what their needs are. It may be anywhere from 2 weeks of inpatient treatment up to 90 days of inpatient treatment. And the drug court provides that access to treatment to them while being supervised by the district attorney's office, the public defender's office, the court. Once they complete their treatment protocol, then they are continuing to be supervised intensively. They have to report to the probation officers. They have to report to drug court. They have to maintain a job. So every case is treated differently, but the success rate has been great for them compared to the national statistics. So in Montgomery County, we have a graduation rate of 60%. And there is a recidivism rate of 27% for drug court graduates, 27%. And the national statistics for recidivism for those who suffer from addiction is 70%. So it's not an easy program to complete, but from talking to people who have graduated, many of them have told me it has saved their lives. Oops, get back here for a second. So one of the other efforts we're doing to combat the opioid epidemic is working with our state and federal partners in targeting dealers and suppliers of drug trafficking organizations. We're using the data that is being collected about hotspots and targeting certain areas where the supply of drugs are increasing, especially the supply of heroin or fentanyl. So in 2017, Montgomery County applied for and was granted status as a high intensity drug trafficking area, or HIDTA. And we are members of the Liberty Mid-Atlantic HIDTA group, which enables us to partner with more than 35 participating federal, state, and local law enforcement agencies to combat drug trafficking, money laundering, drug-related violent crime, gang threats, in not only in our county, but our surrounding counties. We have also used it, and a big focus, actually the main focus in recent years, has been used for the investigation of pill cases, doctor investigations, and drug delivery resulting in death. In our office, we have a designated prosecutor who we consider the HIDTA prosecutor, and she handles all of those types of prosecutions. She works alongside with myself and other members of our drug team in the investigation and the prosecution of cases where we use our HIDTA resources. One of the other things that plays a huge role in our office is that in 2016, District Attorney Steele established a subunit. Montgomery County District Attorney's Office has its own detective bureau, and one of the groups within that detective bureau is our narcotics enforcement team, who are charged with the investigation and prosecution of large drug trafficking organizations. So within that narcotics enforcement team, we have also established a subunit where our local police departments, and we have 46 police departments in Montgomery County, will, for lack of a better word, loan us an experienced police officer who comes to Montgomery County District Attorney's Office, spends anywhere from a year to 18 months with us, and they are part of this subunit, and it's called the Opioid Overdose Investigation Task Force, and their sole duty is to investigate overdose deaths in Montgomery County. Every single overdose death that occurs in Montgomery County is treated as a homicide crime scene. And this group of officers is tasked to be the lead, working with the local police departments to investigate those cases. I'm going to talk a little bit about that some more as we go along here, but curtailing back to doctor investigations. So working with HIDTA is very important, but we also work with other federal law enforcement agencies such as DEA, the FBI, the Homeland Security, and also regulatory agencies that monitor doctors and physicians. And so we investigate physicians who are operating illegally by selling or overprescribing medication to drug-addicted persons. And this is very important because, as you all know, the opioid epidemic, its bedrock started with the increase of use of prescription medication, including opioids such as Percocet and OxyContin. We also have access to and use in our investigations the prescription drug monitoring program, which we have here in Pennsylvania. It's a very important investigative tool in the identifying providers or pharmacies, prescribers who may be dispensing narcotics illegally, and allows us to at least identify them and be able to start an investigation, if need be, into the prescribing practices. It also provides information to doctors and prescribers and pharmacy to see if an individual who's drug dependent are shopping around for drugs. We found from our investigations that several of those people who are addicted to narcotics will visit multiple doctors all in one day trying to get prescriptions. So our doctors in Pennsylvania, our prescribers, and our pharmacies are all tasked with inputting information into this system that is shared among law enforcement and each other, so that they can see who is prescribing and what individual is asking for narcotics. So as we know that the abuse of prescription medication is really the bedrock of this epidemic, and identifying and investigating physicians who are using their positions as doctors to illegally prescribe narcotics to drug and addicted persons is a very important part of our response to this opioid epidemic. Seen here are 5 doctors who were investigated and arrested and prosecuted. Some of these doctors were prescribing medications for money. Some of them were prescribing in exchange for sex. And so we work these investigations, we build up the prosecutions. Some of them were also committing welfare fraud and insurance fraud. So for many of these investigations, we work with our federal partners through HIDA. So instead of helping those suffering from the substance abuse disorder, these doctors did their part to keep individuals addicted and dependent for their own personal gain. So these cases are very important, and they're very important to our community. After the arrest of these individuals and other doctor cases that we have investigated and prosecuted, we always hear back from the community, and they appreciate our efforts and they agree with our efforts, and we believe it has a huge impact in this epidemic. So, as I mentioned before, you know, our office has a real clear understanding that we are not going to arrest our way out of this epidemic. But fighting to get drug traffickers off of our streets is key and is an element in fighting this. This is one of many fronts that we are taking part on. So part of what we're doing in Montgomery County, in addition to everything else, is investigating every overdose death as a homicide. This is no small task, and the investigation and prosecutions of these cases are very complicated. There are a lot of moving parts that you must be mindful of even before charging can be lodged. We are aggressively investigating and prosecuting drug dealers, suppliers, drug trafficking organizations, and if we can prove that they sold drugs that caused someone's death, we are charging what is called drug delivery resulting in death in Pennsylvania. It is an available charge to us. However, not all states have a specific drug-induced homicide charge. So we as prosecutors have what is called prosecutorial discretion. And what we found, and what I have found during my experience in the investigation and the prosecution of these cases, is that this type of drug prosecution looks a little different from traditionally. I've been a prosecutor since 2003. I was the head of the drug unit in 2008. I prosecuted wiretap investigation of large drug trafficking organizations. But what we started to find in response to this opioid epidemic is that the face of the defendants, the face of the dealers, were starting to look a little different. And that is something that I find not only in our community, but across the board. And what we found from these types of cases is that they fall in almost 3 different categories. You have the defendant who is strictly a drug trafficker, a drug supplier, a drug dealer. He is not a user. He is in it to get more customers, or he or she are in it for money. Then you have a large majority of our cases fall within the second category, which are dealers, but they're also users. So these are individuals who are, yes, dealing drugs, yes, have a customer base, yes, are doing it for money, but they're also supporting their habit because they're users as well. And then you have those who are giving or sharing drugs with a family member or a friend, and they are just strictly users. So what we found is these investigations led to this characterization of 3 different types of people who are participating in this conduct. And when I talk about prosecutorial discretion, it's really critical to understanding how important and how careful that we have to be as prosecutors in deciding what we are going to charge. As you guys heard earlier from John, I'm the mom of 3 boys. I've watched a lot of superhero movies, and the one thing when I think about prosecutorial discretion is Spider-Man. And if you've seen the Spider-Man movies, you'll remember that one part where Spider-Man's grandfather said to him, or I believe it's Spider-Man's uncle, with great power comes great responsibility. And I always remember that when I'm reviewing a case and trying to make a determination of what charges, if any, to lodge. So it's really important. You have to take each case as it comes to you. There is no protocol or right, wrong. There's no litmus tests on how to charge these cases because every case is different. So I want to talk a little bit about the law. We have a drug-induced homicide statute, obviously, in Pennsylvania. It's drug delivery resulting in death, and I believe there are 25 states total in the United States that have such a charge. But there are many states that do not. But this case came out of the United States Supreme Court in 2014, and it really is the leading case in addressing drug-induced homicide charge. It explains the burden to establish the charge and establish what is called the but-for test of causation. And we have that here in Pennsylvania. Your jurisdiction may or may not have that. It may have a different test for causation, but there are many states that share the same test, and it's this but-for test. And the Supreme Court ruled that the sentencing enhancement under the federal statute, in this case in Burrage, could not be imposed because the victim in the case was found with multiple drugs, had a combined drug toxicity in the victim's system, and the heroin sold by the defendant could not be considered an independently sufficient cause of death. Okay, well, what does that mean? Basically, what that means is that the expert, whether it was a toxicologist or a forensic pathologist, could not say, but for the heroin that came from this defendant, the victim would still be alive. So, and we're going to talk about multiple drug toxicity and the hurdles and the problems that poses for investigators and prosecutors. But the test that came out of Burrage is, but for the heroin, if it were not for the heroin from the defendant, the victim would still be alive. So that is the test that has come out of and established the burden for these types of cases, and is also applied in Pennsylvania. So as I've mentioned to you, there are 25 states in the union that have drug-induced homicide laws. These laws establish criminal liability for individuals who deliver or provide controlled substances to another individual who dies as a result of using the drug. The laws vary from state to state in how they are classified, how they are sentenced, and what elements need to be proven. They affect many considerations regarding venue, jurisdiction, and defenses. And I want to talk to you a little bit about some of the different states. I'm not sure exactly who is represented here in our webinar, but maybe I'll hit on one of your states. So taking the state just south of here is Delaware. And in Delaware, The statute reads that anyone who delivers a Schedule I or Schedule II controlled substance of a certain quantity. Now, in this statute, in this state, they actually established a certain quantity to another person, and the controlled substance causes the death of another person who uses or consumes it. We're going to talk about Pennsylvania in a minute, but Pennsylvania does not have a quantity amount. It's any controlled substance that results in the death of another. But the Delaware statute is similar to Pennsylvania, that it shares that but-for test that we heard about in Burrage versus United States, and that is the test for causation. It is not an easy test to meet unless you can show that the actual drugs delivered from the defendant killed the victim. And a lot of times, and most of the times these days, our victims have multiple drugs in their system. Now, quickly looking at New Jersey statute is a strict liability statute for drug-induced deaths. That the defendant provided the drug and that its ingestion caused the death of the victim, and there is no mens rea for the intended the result or the outcome. So the law in New Jersey, this strict liability crime, shows that all the state needs to do is prove that the defendant provided the drug, that the victim ingested the drug, which caused the death of the victim. There is no requirement that the prosecutor demonstrate that the accused intended this result or the outcome. Now, in drug delivery resulting in death cases in Pennsylvania, it is not a strict liability crime for that in Pennsylvania, but it's pretty close. I would say there's a little bit of a gray area there. Because we still need to show in Pennsylvania a mens rea, but it's not a mens rea to kill. It's just a mens rea to deliver, to sell, to distribute. And we're going to talk about that in a few minutes. But it's not, the mens rea is the intent to provide the drugs. And the death, we have to show, was the result of the use of the drugs by the victim. And we just have to show that the death was at least recklessly caused by the defendants. So in New York does not have a drug-induced homicide charge. What they do in New York is that they look upon their other homicide statutes in New York. If they choose to charge someone with a drug-induced homicide, they have to kind of fall back on their regular homicide crimes. So again, fatal overdoses can be charged under their homicide statute depending on the facts. And there's a case out of New York, People versus Gowarecki, where sufficient evidence to support the charge of second-degree manslaughter. They charged second-degree manslaughter where the defendant sold heroin to the victim who died from an overdose. So in New York, in that case in particular, they used second-degree manslaughter to prosecute a drug-induced homicide. Okay, so I want to talk a little bit about multiple state jurisdictions in these types of cases. So drug trafficking and drug use, as many of you know, is a very transient type of crime. And the issue of venue and jurisdiction is, although it hasn't been litigated that much, and as a side, I will tell you, at least in Pennsylvania, what we have found is that there really isn't a lot of appellate authority for our drug delivery resulting in death statute, because it really wasn't used until the last few years due to this huge spike in overdose deaths. But I suspect that we are going to start seeing more appellate authority as more of these cases are being prosecuted and tried and appealed. There is some, but the issue of jurisdiction and venue has been addressed in Pennsylvania and was addressed here in New Jersey. So the case that I want to refer to, which came out in 2019, is State versus Ferguson. And it's an interesting case when you're talking about jurisdiction and venue, what court has the authority to hear a case and what venue is proper to hear the case for drug delivery resulting in death when you have individuals who are moving. And in here, there were 3 defendants. There was a defendant by the last name of Burrage who sold drugs to co-defendants Ferguson and Potts in New Jersey. So Burrage sold drugs to defendants Ferguson and Potts. And then Ferguson and Potts took the drugs that they bought from Burrage, traveled to New York, and sold to the victim in New York. And the victim used and died in New York. New Jersey lodged drug delivery, resulting in that strict liability crime against all three defendants. Burrage, who sold the drugs to Ferguson and Potts in New Jersey, and also against Ferguson and Potts, who traveled to New York, gave it to the victim, and the victim died in New York. So the New Jersey Supreme Court held that the state could not bring the charges against the three co-defendants because the use and death of the victim occurred in New York, where there is no such crime. As I just mentioned to you, there is no such crime of a drug delivery resulting in death type of statute like there is in New Jersey. And the use and the death of the victim, which were elements of New Jersey's statute, is not a crime in New York. In other words, although the drugs were sold by the defendant Burrage in New Jersey and the victim used the drugs and died in New York, New Jersey did not have what they called territorial jurisdiction to prosecute any of the defendants for the drug-induced homicide, because that crime does not exist in New York, where two of the essential elements of the offense took place, namely the use and the death of the victim. Now I'm jumping around a little bit here, but I want to kind of turn our attention back to Pennsylvania and some of the possible felony crimes and charges that we consider when we're investigating and prosecuting these types of cases. Obviously, the first one is drug delivery resulting in death. We also consider for those cases that we might not have enough to meet our burden for drug delivery resulting in death, we entertain possession with the intent to deliver charges, which is our felony drug trafficking charge. That also includes the delivery and the manufacture of drugs, and also acquisition by fraud, which is obtaining prescription medication by fraud. I don't see that as often. I don't think I've seen it yet, but that is a possible charge when considering what the proper charges are in these cases. So in Pennsylvania, our drug delivery resulting in death charge is codified at section 2506 in our crimes code. We do not have a mandatory minimum in Pennsylvania for this charge. There are states that do have a mandatory minimum. We have a statutory maximum sentence. Actually, it's written right in the crimes code in section 2506 that those who are convicted of drug delivery resulting in death are facing 20 to 40 year statutory maximum sentence. The offense gravity score, which what we have in Pennsylvania is a 13, and if what I'm not sure what other states do, but we almost have like a grid in Pennsylvania where it matches off the offense gravity score with someone's prior record, and then comes up with standard guidelines in which someone can be sentenced, and obviously a judge can depart from the guidelines and aggravate it depending on the facts and circumstances, or mitigate it. But to give you an understanding and just a little snapshot of what someone with no prior record score is facing if convicted of drug delivery resulting in death, the standard guidelines fall between 5 and 6.5 years. If somebody has a significant prior record score of, let's say, a 5, their guidelines fall between 8 and a 9.5 year sentence. So our drug delivery resulting in death statute, the elements include the intentional administration, dispense, delivery, give, prescribing, sell, or distribute of any controlled substance and or counterfeit substance in violation of section 30, which is our possession with intent to deliver statute, our drug trafficking statute. Now here, unlike Delaware, we do not have a threshold quantity amount. It is any controlled or counterfeit substance. And the last element is any person dies as a result of using the substance, and death must be at least recklessly caused. And I'm going to talk about that in a minute. And these elements are explained through the limited appellate authority we've had so far in the last few years. But one of the leading cases is Commonwealth versus Cocacan. And in this case, the defendant challenged the constitutionality of the statute. And the question was, is the statute unconstitutionally vague? Does it fail to identify the requisite mens rea for establishing guilt? And what the defendant said here, there is not the proper mens rea in the statute, and it should be void for vagueness. Does it fail to clearly indicate the requisite level of causation with the term result of, which is in that third element of the statute. And our superior court said, no, the requisite mens rea for establishing guilt is intentionally. The statute's very clear. That is the mens rea is the intent to deliver, the intent to sell. Again, not the intent to kill. And the court also explained that the result of language that is in that third element of the statute is equal to that but-for test that was described and explained by our United States Supreme Court in the Burrage case. And basically, but for the defendant selling the victim a bundle of heroin, in this case, the victim would not have died of the heroin overdose. So the court also went on to explain that the applicable mens rea for the crime, again, is that intentional delivery of the drugs to the victim. The actual death must be the reckless result of the actions of the defendant. And this court, I would argue, if you read the opinion, it's very interesting. They take almost judicial notice of the fact that the sale of heroin alone, just the sale of heroin alone, the dangerousness of it is so wide known and is considered reckless. So the sale of heroin alone in and of itself is considered reckless. So once you prove that intent to deliver heroin or an opioid such as fentanyl or some other type of controlled substance that can cause death, that in and of itself meets that reckless requirement and is foreseeable. I also want to talk a little bit about combined drug toxicity, and this is probably our #1 issue that we face in the investigation and prosecution of these cases. I will tell you, these investigations for our law enforcement officers are time consuming. They can be very stressful. Time is of the essence in our law enforcement investigators' response to overdose drug scenes. And they have to start putting the building blocks together in their investigations from day one. And it might not be until 6 or 7 months later until we find out from the coroner what exactly killed this individual. And what can happen, and we're going to talk about this in a few minutes, is that despite all the efforts in putting together the best case that shows that drugs were delivered to the victim from a particular dealer, we may not be able to meet our burden for drug delivery resulting in death because of that but-for test that requires us to show that the drugs that killed the victim came from the defendant and the drugs that killed the victim caused the victim's death, despite other drugs that may be in their system. So this issue was addressed by the Pennsylvania Supreme Court in Commonwealth versus Proctor. And the question there was whether the court erred in instructing the jury that the final element of the drug delivery resulting in death is that a person died as a result of using the substance, even if other substances were found in the system. So the trial court instructed the jury that you can still find the defendant guilty, even though that there were other drugs in their system, as long as you believe that the drugs that came from the defendant did in fact kill the victim. And a lot of times, actually most times, that is proven with expert testimony. We'll get to that in a minute. But the court held that the final element in drug delivery resulting in death, the death resulting from, is the but-for test for causation. The fact that the decedent had other drugs in his system is immaterial, the court said, as to the causation when the heroin level was at a lethal level and was a direct and substantial factor in causing the death. Getting that evidence that that particular drug, and in this case in Proctor was heroin, was of a lethal level comes through expert testimony. Montgomery County, we use both a toxicologist and a forensic pathologist, a coroner from the coroner's office in our investigations and prosecutions, but that is the key to the successful prosecution of these cases. So again, I know some of my colleagues in other counties, they do not have the resources or they just don't have the coroner's office. on board in these types of investigations. And so a lot of times they're bringing charges based on just a toxicology report, and that's okay too. That's okay too. And there has been successful cases in that. But what we do in Montgomery County is we have a great relationship with our coroner's office. They understand, they're part of our overdose drug task force. They're part of our efforts. They understand what we're doing as law enforcement officers. And so they are investigating these cases, overdose death cases that are coming into their office, and they're providing us with expert opinion, and they're making themselves available as well to testify when we need to call them. So the importance of expert testimony is critical in the successful prosecution of these types of cases. Most cases, as I mentioned before, that we are seeing in the last few years are mixed toxicology cases. Unfortunately, these victims can have a pharmacy of drugs in their system, and to really show that the drugs that killed a particular victim came from the defendant is really tough. When you have an expert, whether it's your coroner, your forensic pathologist, or your toxicologist, who cannot say that those other drugs in their system didn't contribute. So again, we're a but-for causation state, and we have to show that it was the drugs that came from the defendant that in fact killed our victim. So the but-for the use of heroin, these are some of the questions that we ask our experts. And our practice in Montgomery County is that once we get the forensic pathology report and the toxicology report, I pick up the phone and I schedule a meeting and I go and meet with them personally. I want to review them. I want to ask them questions as if they were on the stand. I want to make sure I have a full understanding what their opinion is going to be. And unfortunately, there are many, many times where I have every I dotted, every T crossed. The investigators did a fantastic job. We know that this defendant delivered lethal drugs to a victim, but we're not going to be able to charge drug delivery resulting in death because the expert cannot say that the other drugs in their system did not contribute to the victim's death. So it's really important to make sure you have a full understanding in speaking with your experts about what their opinion is going to be before you make that decision on charging. So again, just to reiterate, you want to make sure that they can say that to a reasonable degree of scientific, if you have a toxicologist, or medical certainty, if you have a forensic pathologist who's a doctor, that the victim would not have died but for the use of, I use heroin here, but it could be any drug. You can fill in the blank, depending on what drug the victim took that came from that dealer. Moving on to another very important case that came down in 2017 from Monroe County here in Montgomery County is Commonwealth versus Story. I'm sure you all have seen many factual scenarios that are similar to this, where you may be able to, through your investigation, to establish, starting from the response to the overdose death scene, starting with your victim, you may, and we're going to talk about this in a little bit, you may gather evidence that includes a cell phone, which leads you to maybe the last person that this victim may have communicated with, which could be a friend, or it could be the dealer, or it could be both. And then you may be able to establish through the collection of evidence the chain of supply. And so in this case, in Commonwealth versus Story, the Commonwealth was able to charge the actual supplier of the heroin that went through a middleman and then went to the victim, the end user. And in this case, in Story, the supplier didn't even know who the victim was. And the court examined the statute in relation to the chain of supply from supplier to the end user when the end user and supplier never met. And you may find many cases in your jurisdiction that meet that same type of factual scenario. And the appellant claimed that because he did not know the victim who died, he could not be found guilty of intentionally delivering heroin to him. But the Story court said no. The court disagreed, finding that Story's lack of knowledge of the end user of the victim was immaterial, and held that the statute requires only that another person dies as a result of using the substance sold. I currently have a case in Montgomery County that I'm prosecuting, which looks just like that. I have a supplier who is from Philadelphia, our neighboring county here, who did not know my victim. His supply of drugs went through 2 other people before it even got to the victim. It went to his sub-dealer, who was also a user, who kind of falls into that second category that I talked about earlier. And then those drugs went to the victim's friend, who is a user himself, and the victim's friend gave the drugs to the victim, and the victim ultimately died. So what did I do in that case? In that case, I charged the ultimate supplier, the defendant, where the drugs came from, where the drugs originated, with drug delivery resulting in death. I charged the middle person because based on the investigation of the evidence in the case, it was clear that the middle person, although a user, was also a dealer and had a huge customer base. From search warrants that we executed, we knew, and from interviews that we conducted, we knew that he was not only using the drugs, he was selling them for a considerable amount of money. And there was also evidence, although we couldn't prove it, that he may have been responsible for the death of another individual in that jurisdiction. And then the user friend, for lack of a better word, that provided the drugs to the ultimate user, we charge with involuntary manslaughter, which is a misdemeanor charge. And both the friends and that middle person have already pled guilty. They haven't been sentenced yet, and they have both given statements and have agreed to testify against that ultimate supplier. So that's what we, whoops, skipping ahead here. I don't know what happened, sorry, go back. So that's what we did in that case, and the Story case allowed us to do that. Second, your indulgence, please. Okay. So as I talked about earlier, drug use, drug trafficking is very transient, and venue is an issue in these cases that we have found. Defendants and sellers, users often cross not only state lines, like in the Ferguson case, but they can also cross county lines within your own jurisdiction to buy, sell, and use. So Pennsylvania is one of the only states, in addition to New Jersey now, that has addressed the issue of venue in DDRD cases. And there's a case, Commonwealth versus Brown, which is out of our Pennsylvania Superior Court. And in this case, the defendant and the victim traveled from Center County, actually State College, which is Penn State land. And they traveled from Center County to up here in Clinton County to buy what they thought was heroin. The defendant delivered the drugs to the victim in Clinton County, okay? And then they both returned to Center County, and it was in Center County where the victim used and died from the drugs that were delivered by the defendant. So the defendant was charged with DDRD in Center County, and the trial court granted the defendant's motion and moved, it was a venue motion, and moved the venue to Clinton County, stating that the only overt act was in Clinton County and the action should have been brought there. The Superior Court reversed and held that venue could have been brought in either county because venue would have been proper where any of the elements of the offense occurred. Now, in Peck, there's another case, Commonwealth versus Peck, which is also a Pennsylvania Superior Court case where the decision is pending. And in that case, the victim died of a drug overdose in Pennsylvania after he had purchased the drugs at a state in Maryland. And the Superior Court affirmed the conviction of the DDRD where even though the delivery took place in Maryland and the death was in Pennsylvania, and similar to that Ferguson case under the New Jersey statute, Maryland, like New York, does not have a drug-induced homicide statute. So it's going to be very interesting to see what the Pennsylvania Supreme Court says in relation to the case on whether or not Pennsylvania has territorial jurisdiction over the offense. Because one of the elements, the delivery of the drugs, took place in Maryland. So we are watching for that case. We'll see what happens. But if it follows New Jersey's suit, the way the New Jersey analysis, it may be that our Supreme Court says Pennsylvania does not have territorial jurisdiction because one of the elements of the offense took place in a state that does not have a drug-induced homicide charge. Other charges to consider in the investigation prosecution of these matters. We've talked a lot about drug-induced homicide, drug delivery resulting in death, as it's called in Pennsylvania. But some of the other charges we look at is involuntary manslaughter, which I talked about briefly with my 3 co-defendant case that I have. It's a misdemeanor charge. That is something that we look at for those who are people who just hand the drugs, aren't necessarily dealers. There's no evidence in the case that they're doing it for financial gain or to create some type of customer base so they can continue to distribute drugs. So we in our prosecutorial discretion, again, looking at every case individually, weighing all the totality of the circumstances before we make that decision, that is one of the charges we consider. Another charge to consider, and we haven't done it yet in Montgomery County, but I know there are some other counties in the state that have charged third-degree murder. And that's a possible charge with the right facts and circumstances if there is an element of malice in the death of the victim. One of the things, and I talked about this earlier, is our partnership with our federal authorities. It's very important, especially with our U.S. Attorney's Office. If you have the ability to work with them, it is a great partnership that we enjoy here in Montgomery County and can really open the doors to other things. And myself and some other prosecutors in my office are specially designated as United States attorneys so that for the right case, we can bring a case to the Eastern District of Pennsylvania for prosecution. And they also have a drug delivery resulting in death type of statute called the distribution resulting in serious bodily injury or death. But the interesting thing about the federal statute is that death doesn't even need to result. If you can establish serious bodily injury, you can still charge under their version of the DDRD statute, and their guidelines and their sentencing enhancements are far above what we have at the state level. The type of case that we have done this in so far, and it's only been one, and I'll just briefly talk about it, was a case that started with the Pennsylvania State Police. They had information and built an investigation around an individual who was living in one of our township and was receiving packages from China with synthetic opioids. And with those packages, he was also receiving instructions from his China counterpart who was instructing him on how to package the synthetic opioids, where to send it, and he was sending these small little packages to people all over the country. And through that investigation, we were able to see that it had far-reaching tentacles in other parts of the country, far beyond Montgomery County. So we worked with our federal partners, brought that case, and it was indicted federally. And they worked with Homeland Security, they worked with FBI, they actually identified the China contact who was providing the instructions and providing the synthetic opioids to this individual right in Montgomery County. And they were also able to identify at least 10 different overdose deaths that occurred in Montgomery County as a result of these in the United States. 10 overdose deaths that occurred in the United States that resulted from these packages that came through Montgomery County. So that case we felt was right for federal prosecution, and I believe it is still pending. And one of our other prosecutors in our office, actually our HIDA prosecutor is handling that case. To give you an idea, I talked about the hurdles with these investigations, how difficult they are. So since 2016, when we established this opioid Overdose Drug Task Force, since the grand jury report, we have investigated 465 overdose deaths in Montgomery County as homicides. We've only brought charges for drug delivery resulting in death in 27 of them. 7, we charge involuntary manslaughter, and there are others that we charge PWID and some other related charges. And the reason for that is because they're very difficult to investigate and they're very difficult to meet our burden under the current law. So part of the success of these cases that is necessary is the comprehensive and quick response by our investigators. So here in Montgomery County, I talked about that subunit that's part of our narcotics enforcement team who are just designated to investigating overdose deaths, treating them as crime scene. And we actually put together, our district attorney put together a county protocol. We have 46 municipal police departments in our county, including the Pennsylvania State Police. So we have issued a protocol and policy on how to investigate these types of cases, what to do. And it's been a huge learning curve. We've conducted trainings for our police departments, and you know, it's not perfect, but we've come a long way, and I'm really proud of the work that they have done. So building those, putting together those building blocks is essential to the success. Again, we have the policy for the investigation of overdose deaths, and I am willing to share that if anybody would like a copy of that. The initial response and the collection of evidence is paramount. Evaluating phone evidence is very important. The first thing we look for, and the best piece of evidence, is from the victim's phone. 9 times out of 10, the victim who they last spoke with was the dealer who gave them the drugs, and we can build a case from there. So a lot of times these cases follow suit with one, identifying who the dealer is through phone evidence, and then law enforcement connecting with that dealer. And in Pennsylvania, under the Wiretap Act, they are allowed to assume that phone and conduct undercover operations where they act as if they're the victim asking for the same drug. So you have a situation where the police respond to an overdose death scene, they assume the victim's phone, they can clearly identify who the dealer is, because a lot of times the text messages are very clear what happened. A lot of times they assume the victim's phone, and the text messages are still coming in asking the user if he wants more drugs or how the quality of the drugs are. So under the Wiretap Act, we can give the police permission to assume the identity of the victim and make contact with the dealer and try to get the dealer to come out and deal exactly what they just dealt to the victim previously that ultimately killed him, and then we could build a case from there. So that is one investigative method that has been successful. Not successful necessarily, I'm not going to say successful that we're being able to charge DDRD every single time, but it has been successful to identify who is distributing drugs in our community, and maybe it results in just a possession with intent to deliver charge, and that's okay too. But again, identifying who these people are who are infiltrating our community with this type of poison that is killing people, we want to know who they are, and we want to do everything we can to make sure that we can curtail their flow of supply. Finding key witnesses and taking statements. The phone evidence, again, is critical. We need to know about phone calls and text messages, executing search warrants. It's very important to take a look at social media sites. If you have probable cause to do so, taking a look at Facebook Messenger, Snapchat. These are all things that we have done in our investigation. Search warrants for videos or phones. We do search warrants for call detail records so that we can corroborate what witnesses are telling us. And we can also look at the path of trial and the location of both the victim and the defendant, or the target, the person we are investigating, at the time that we believe that he received the drugs from the defendant. So these are all investigative tools that are really necessary in these types of investigations. And again, doesn't necessarily mean that we're bringing a DDRD charge because of our burden. some trial considerations. So we must be very mindful of where people are in our society and in our community with regards to their feeling about the opioid epidemic. And in my experience, I have found that people are really all over the map. There are those who are very supportive of what we are doing and believe that the victims' families deserve justice. They support these types of investigations and prosecutions. And they feel that the defendants should be held accountable. Even if we can't bring a DDRD charge, they want them off the street. So we have individuals who are very supportive of our efforts, but there are many, many people who feel that what we're doing is a waste of time, that feel like it's a waste of resources, and that this is just another example of us losing the war on drugs. And, you know, it was the victim's choice. The victim assumed the risk. So why are we doing this? And they are really good questions. And as prosecutors, we really need to be mindful and have an understanding that there are people that feel on these two very opposite views. And you really need to know who they are in your jury pool. And a way to do that is through jury voir dire questions at the beginning of a jury trial. You want to see where people are on these types of issues, because at the end of the day, you just want to be able to impanel someone who is fair and impartial and who can follow the law. So the assumption of the risk defense is something that I haven't quite seen in our county yet, although from conversations with defense attorneys on many cases, I know that that's where they're going. We've had, I believe it's 29 DDRD arrests or prosecutions since 29 cases where we charged DDRD, and out of their 29, since 2016, we've had 3 jury trials. Most of them result in negotiated guilty pleas to DDRD. But through my experience and, you know, and speaking with the courts and with defense attorneys, you know, part of their strategy is to blame the victim. And that is something that we all need to be mindful of and be able to address. And there are some states, not necessarily but-for states, but there are states where it's even harder than the but-for tests to bear the burden of this charge, because they have an approximate cause, that legal cause type of burden, where there could be absolutely no other contributing factors in causing the death of another person. So the assumption of the risk defense is a real problem for them there. You may want to, if the facts and circumstances are right, to file a pretrial motion to avoid that attack on the victim. But I would actually suggest against that. What I would suggest is that you are very upfront and honest with the jury about who your victim is, that they are victim of the defendant because they were preyed upon because of their disease. Some jurisdictions, I've read, actually the National District Attorneys Association also has some great resources available, and I've read on many of their publications from individuals who have prosecuted these types of cases, that some of other jurisdictions have called expert witnesses in to describe the disease and also describe about the addiction. So that might be a possibility for you, or to have a drug expert, have one of your law enforcement investigators who are an expert in drug trafficking and narcotics investigations to talk about their extensive experience in drug investigations. They have seen it all. They've talked to dealers, they've talked to users, they've talked to family members. They can really give the jury insight about how strong this addiction is. So I always take the position, really in any jury trial, that I like to take the wind out of the defendant's sails, and I'll put my problems with the case up front. And try to address it head on, because there's no hiding that our victims are drug users. There's no hiding that they are they have a substance use disorder. So again, we want to find a way in your case to shift the blame from the victim and focus on the drug dealer's actions. Focus on whether the dealer knew the victim was a novice user, which is a really good point. Now, it might not be as important to meet your burden, but that may be a really important consideration when it comes to sentencing. So if the defendant who is charged with drug delivery resulting in death knew your victim was a novice user, but continued to encourage him to try or to use opioids, especially if it's fentanyl, especially if they're a new user to fentanyl when they are traditionally a heroin user, that could be a really good piece of information that the court should know before fashioning a just sentence on the defendant. And again, as I mentioned before, expert testimony at trial or at sentencing regarding addiction and its effects could be warranted. I wanted to end here with this slide. The question that I hear all the time is, why do you do these cases? Why is it important? Well, is there an impact on the community? Is there a deterrence? Well, these are some of the faces of the epidemic in Montgomery County. These are individuals who have fallen victim to this disease and the substance use disorder. And each of these individuals have family members who cared for them, who supported them, and supported our efforts here in Montgomery County. And although our efforts cannot bring them back, our efforts have provided a measure of justice and closure for them. And again, it's not just about the investigation and prosecution for drug delivery resulting in death. It is the all hands on deck, comprehensive, collaborative effort that my office, as well as all the other offices in Montgomery County, are doing together. And this was actually from the brother of our one victim here. Her name was Jackie Hauser, and this was sent to me a year after she died, and they received justice. So I just want to end on this. This is why we do it. It's one of many things, and I'm really proud of the work we have done. I'm willing to answer any questions you may have, and thank you for your attention.
Tonya, thank you so much for that presentation. Such fantastic information and so much to really think about and helping us understand and learn about the practice in Montgomery County. We do have a few questions from our participants. If I can pose them to you now, if you're ready, or if you need to catch your breath first.
No, I'm good. I'm good.
All right. Great. Well, one of our questions, I'm just going to read it verbatim. One of the questions is asking if you can give any more detail on the emergency medical surveillance system you mentioned. What data sources or platforms, RMS, EMS, ER are available to you? How are notifications, I guess, about additional data to the platform handled? And who's responsible for the analysis and any product of the emergency medical surveillance system?
So that's a really great question. And I will start out by saying I am by far an expert actually in that. But what I can tell you is that I can share with you, if you provide your email address, we have a whole pamphlet on it that provides that information. It is data that is shared among our county stakeholders based on the use of naloxone for overdoses that are fatal and overdoses that are non-fatal. So it is collected by our Department of Public Safety. So they're not only collecting that data from police departments, they're also collecting that data from emergency medical services. And it is a very comprehensive program. I would absolutely tell you to send me your email address, and I can get you in touch with the people who wrote for and was awarded that grant, as well as get you some information with regards to how it's implemented. So it's definitely a great investigative tool. Now for us as law enforcement, our detectives and our investigators look at it all the time to identify hotspots, and it's really critical in our response.
Thank you so much. Our next question is drawing on your deep and broad knowledge. Are you aware of any cases of children overdosing on Suboxone in any form?
You know, it's funny that you asked that, because just in the last week or two, we actually have an investigation into that exact fact pattern in one of our townships. I'm not sure where it is at this time, but we have not charged that type of case to date.
All right. And the other question we have, I think it's asking for a peek behind the curtain at the Montgomery County DA's office, and just about how you apply the prosecutorial discretion, asking for if you could sort of illuminate about some of the criteria you use for charging delivery causing death for persons who are small-time dealers or simply users. The division you have into 3 categories is very helpful, but any perspective you could offer on how you decide when to issue the delivery causing death would be helpful.
Right. So we have a team effort in making that decision, and there's a lot of things that go into it. And I can talk about some of the things that we look at, but please know that those decisions are definitely not made in a vacuum. There is no litmus test. Every case is different. And it's a really, really difficult decision to make, and one that we do not take lightly. But we want to know about the defendant's background. We want to know about the facts and circumstances surrounding this case. Were they encouraging use? Does the defendant have a customer base? Is he continuing to deal drugs? How often is he dealing? I mean, these are all decisions and questions that go into it. If they are, just users down on their luck, we do not charge drug delivery resulting in death. I know technically we can, but we feel a very strong sense of responsibility to look at every case individually. We work with our investigators, and together we make that decision. But again, it falls on our decision on whether or not this is somebody who is distributing drugs that are killing people. So we are very mindful of that. And again, I'm sorry I can't be in more detail. Every case is different. But as you can see, out of the 460 some cases we've investigated since 2016, I believe it's only 27 where we charge DDRD.
If the suspect has retained counsel, do you ever reach out to counsel to ask for more background on that suspect to aid that prosecutorial decision? And if you do, how do you weigh it, or has that not really come up yet?
Right. No, that issue has not come up yet. I will say, looking back, thinking about that, usually these defendants, based on our investigation, we may arrest them for possession with intent to delivery first. So when you have a scenario, let's say we actually, on Jackie, who's still up on our screen here, when the police responded to her overdose death scene, they assumed her phone right away. Her daughter was actually present on scene. It was her daughter's dealer, because both her and her daughter were using together. They immediately made contact with the defendant, who, by the way, was just a dealer. He was not a user. He had multiple people that he was dealing to in that particular township, and he didn't even live in Montgomery County. No evidence of use at all, and just evidence of dealing, quite frankly. Anyway, so we immediately assumed the phone. The officers acted as if it was Jackie asking for more drugs, and the defendant within a few hours returned to her residence to deal the same type of drugs and the same type of packaging that she had used. And we arrested that defendant on the spot for possession with intent to deliver. In that case, we got high bail. The defendant was incarcerated until trial. It ended up being a negotiated guilty plea, but eventually we brought the drug delivery resulting in death cases once all the other I's were dotted and the T's were crossed, and the coroner's office were able to give us an opinion that the drugs that came from that particular defendant did in fact kill her.
Right, and I know we just passed the 3:30 mark, but we have one more question if you have time for it. Well, we just got a second question, but are there protective services for those that disclose dealer information to aid in prosecution? How do you keep cooperating witnesses safe?
Right. So that's an issue that we deal with all the time. Some of our cooperating witnesses are are in jail, waiting for trial. So, you know, in those situations, we make sure that they are separated from their co-defendants in jail, or maybe we move them to a different jail depending on the facts and circumstances. We also have, I've personally worked with the officers, because some of these cooperating defendants, they'll get their attorneys, and I'll work with the officer and the defense attorney to make sure that they are in a safe place, that they are receiving treatment. And we, luckily in Montgomery County, we have so many resources that I can at least put them in touch with who they need to be to get what they need. A lot of times we find that some of these people who are cooperating end up in long-term inpatient treatment facilities. And that, to me, was the best scenario, because they're getting the treatment that they need. And then when they are discharged from the treatment facilities, you know, we hope and we pray that they're in a better place, getting their lives back together. And then if we need them to testify, they're prepared to do so.
All right. And the last question, I think, is more just a compliment to how much everyone loved the information and how much you inspired them. They asked if you have an email address you can share. So, and if you're willing to share it, we can provide it with follow-up from today.
Absolutely. And I'm remiss with not putting that on the PowerPoint. So if you have a pen and paper, you know, feel free to email me anytime. I'd love to help or answer any questions you may have. And my email is TLUP, as in Paul, INAC. So TLUPINAC at, it's Monco, PA. So it's M as in Mary, O, N as in Nancy, T, COPA.org. So TLUPINAC at Monco, PA, MONTCOPA.org. And you can always call the office right now. We're all working remotely in Montgomery County. There's a very small group of ADAs that are actually in the office, and that changes from week to week. But if you call the main line and you're trying to get a hold of me, I will get your message and we'll call you back.
And one of the things for folks still in attendance, we will be following up with the request for evaluation as well as our follow-up questionnaire. And we can also provide Tonya's email address with that follow-up correspondence to everyone. Well, Tonya, thank you so much for your time today and all the information you gave. This has been fantastic. And I know you've done a great service to all the IPS folks watching today. Thank you so much. And thank you for your job and the work you do in your community and in the nation generally.
Well, thank you very much. It was a pleasure. Thank you. Have a great day, everybody. Stay healthy and safe.
Thank you. Bye-bye.
Bye-bye.